The Pietermaritzburg High Court has granted former President Jacob Zuma's request to have his plea hearing in the arms deal corruption case to be heard in open physical court. This means that the former president will give any evidence in person. Initially, Zuma was scheduled to give evidence virtually due to the COVID-19 restrictions. His lawyers argued his rights would be compromised if the matter was heard remotely and he had to testify from prison. Zuma is due to give evidence on the 10th of August in his plea to have Advocate Billy Downer removed as the prosecutor in the arms deal case. We're joined now by the legal analyst, Advocate Romeo Ntambaleni. Mr. Ntambaleni, good evening to you. Thank you very much indeed for your time. There's actually quite a lot to look at in this case. I suppose the question is it right to say that a person has a right to be in a physical hearing rather than a virtual hearing?
Okay, thank you. Good evening, Stephen, to you and the viewers. That's an important question that you're asking. And yes, the provisions of the Criminal Procedure Act and the Constitution says that a person should be present in their own trial. And I think that is why the court has actually ruled in favor of the former president to be present in court. And despite the existence of the Disaster Management Act regulations, and Stephen, I can say to you that this is a problem that you face when you are dealing with an antiquated legal system. That's the problem that you will face.
I suppose somewhere in all of this is the right of access to your lawyer. And that's usually defined, as I understand it, as involving a privacy within a proper conversation. But communication between human beings is not just you and I talking as it is now. I can see whether you like my question from the reaction on your face. I can see if you don't like it from the reaction on your face. But in this conversation, if you and I were client and lawyer, it might involve me tapping you on the shoulder. It might involve me as your client in court just looking at you in a particular way, and you would know what I mean when I do that. Would that all be part of this? That would be something you can do in a physical courtroom, but you can't if I'm testifying remotely from a prison cell?
Yeah, definitely. All the above, Steve. You've mentioned quite important gestures in terms of communication and language. And let's not forget that the lawyers and their clients actually have to talk in real time. So in terms of watching the demeanor of the witnesses and being able to communicate with your legal representative in real time, that is when this legal technology of virtual courts and virtual consultation gets tested. So all those that you have mentioned are quite important in a relationship between an attorney and their own client. And that is the sanctity of the provisions of the Criminal Procedure Act right with the Constitution. So hence, I'm saying to you that when you're dealing with an antiquated legal system, you have those kind of problems. It was so difficult for us to move from saving a service process in terms of the rules of court when you actually have to serve using an email, because the rules does not allow that. They say that there must be real personal service that is served on Stephen Crotes. So if you have not served and you want to serve, you cannot find him. The court has allowed rules for alternative method of service, but you actually have to go to court and ask and say, I'm not finding him. Can I use a different alternative method outside the rules of court to be able to serve this person? So all these important factors that you are raising are very much important, and they talk to the right of an accused person in court, having to interact with their lawyers in real time.
So often you and I have had conversations, and I've had to end them recently by saying, I'm sure this will go to the Constitutional Court. But isn't this actually a question for Parliament? This is something Parliament should decide. I mean, even before COVID-19, it used to be quite difficult for correctional services to get prisoners to court on a daily basis. They started in some cases to actually have virtual hearings because it was just safer. It's much harder to escape from prison than it is from court. In the end, all of that could have to be done away with unless Parliament just changes the law, and I imagine it can do that.
No, definitely, Steve, you are correct. Look, let's look at the time that we are living in now, and the requirements that were brought in through COVID-19 in terms of changing the way the world works. So you are quite correct that this is the duty of the legislatures to actually look at the wholesome legislation to say that the previous antiquated method that we are actually using have to actually move with the time in order for us to be able to allow the rules to serve and do trials virtually, and the law must be read in terms of what is actually happening currently on the ground today. So that we have to avoid the situations of people raising their constitutional rights. So the whole overhaul of the Criminal Procedure Act and the Constitution as well by the parliamentarian must be done. And that's not only the issue in relation to what we are dealing with now, Stephen. You can see the mess that is happening in relation to the elections as to what is supposed to happen now, because the elections are supposed to be held, and what is the conditions of actually holding these elections within the framework of the law, because the Constitution says that there must be elections. And what do you do when you've got a pandemic, and how are you going to conduct and hold those elections and declare them free and fair? So those are prominent, pertinent questions that parliamentarians should be looking at now.
Advocate Romeo and Tambaleni, always appreciate the time. Thanks very much indeed. It's an important conversation. Well.